Hello, all.
Hi, Jim.
Hi there.
We can hear you.
You good? Yeah, exactly.
Yes.
Always checking. Listen, we're going to call an audible here, and we're going to do Moore or McClooney first, and
Oh,
they're both on their way down, and then I'll go back over for the Fiacca Huckfi guy. But
okay.
yeah, McClooney or Moore, I'll call their names out when we get ready to roll.
Makuni and more. Okay.
Yeah, they were two and three on my list that I sent you.
Yes.
Okay.
Okay.
All right.
Thank
Back
you.
soon. Hi, Ashley.
Oh, she's not. That's
Yeah,
okay.
that's okay.
Kathleen. Oh, Kathleen.
Yes.
He changed the list. Makuni goes first, and then Moore. Antonio Moore. Okay.
Okay. All right. Thank you.
You're welcome.
Bye.
Hi, Judge.
Good afternoon.
Hi. I'm calling audible here. We're going to do Moore or McClooney first, if
Okay.
you have my list, and then we'll cycle back and catch up the Fuhakafai, number
Okay.
three. And they
Okay.
are coming down the steps now, just a few more minutes.
Okay. Looks like we're still waiting on
Right.
their attorney, but other than
Right.
that,
Right.
we're all here.
Okay. Yeah. Have a seat right there. Okay. I'm going to go silent. I'll be back when I see them show up.
Okay, thank you.
And while we're waiting, I've got Troy McClooney sitting first, just so everybody knows.
Thank you.
Thank you.
You bet.
Did you get all my emails, Shane? There were 3 of them.
Oh,
One had most of them. One was an assertion that I do not have a police report on Young, and
I
the
got
third one was Mr. Davis, because I
Uh-huh.
missed him in my general roundup.
I think when you sent the one on Mr. Davis, for whatever reason, I can't see the attachments in that
Okay.
email string that you sent previously.
I'll
but
do
I
it
got-
again.
I got the other ones.
Yes, sir. No problem.
Thank you very much.
Yep.
We're
Hey,
ready,
Shane,
Mr. Doyle,
yep.
looks like.
understood. Shane, Mr. Troy McClooney will be up first.
Thank you.
You bet.
Good afternoon, Mr. McClooney. I'm Judge Schultz with the Kansas City, Kansas Municipal Court.
Good afternoon.
It looks like you're not being held on the city case. It looks like you do have a county case pending. I am only a municipal court judge. I don't have anything to do with that. But the city case that you do have, the allegation is a criminal damage. That was
Yes, ma'am.
alleged to have occurred October 12th of 2024 in the area of 7616 Longwood. It looks like last time we spoke to you, you were kind of trying to figure out what was going on with your district court case. We'll have you kind of leave the headphones on, tell the person that gave you the headphones that you need to go to the breakout room, and we'll let you talk to Mr. Lilich
Okay,
about that, okay?
okay, thank you.
All right.
Waiting on our invite.
Mr. Lilich, did you have an opportunity to speak to your client?
I did, Your Honor. Thank you. The city has made a plea offer to resolve Mr. McClooney's pending criminal damage to property charge. I have reviewed that with him. He has advised me he has a court date in Wyandotte County District Court on July the 11th. He'd like to further consider that plea offer and possibly discuss it with his felony counsel. Judge, I'd ask that we set this, that the court consider setting this for review past July the 11th. Order Mr. McClooney to personally appear at that time if he's released. Judge, Mr. McClooney advises me he's been incarcerated since January. If he has not already been granted an OR bond on this case, I would request that the court grant him an OR bond.
He already has an OR bond. I'm trying to see if I can see when. Oh, let's see. That one says OR remains. So we granted him an OR bond on the city case back on January 29th of 2025. So he's had an OR bond with us.
Oh,
And I
never
do
showed up to that.
see that your county case is set for July 11th. Ms. Hutton, is the city opposed to this continuance?
No, Your Honor, not at this time.
Okay. Let me just look at the calendar real quick to make sure we get a Friday after July 11th. We could do either July 18th or July 25th. Do you have any preference?
Mr. McClooney, do you have a
Oh, I
preference?
thought you were talking. I'm sorry.
Well, I
July
was asking
18th.
everybody.
July
Oh.
18th sounds possible. Yes.
Okay, fantastic. So it'll be July 18th at 1 p.m. If you're still in custody on that county case, we'll see you by video. Otherwise, you'll need to appear in person at City Hall July 18th. We'll send paperwork over to the jail. They'll give you a copy showing July 18th at 1 o'clock if you're released, okay?
Okay. Thank you.
All right,
Appreciate
thank
you.
you. Have a good day.
You too.
Mr. Moore.
Okay, sounds good. Good afternoon, Mr. Moore. I'm Judge Schultz with the Kansas City, Kansas Municipal Court. Can you hear me?
Yes, ma'am.
Okay, so it looks like Shane, he would have to post a $500 cash bond on the city cases that are pending. Here are the charges that are pending. It looks like there's one traffic matter that's in a payment status. Then the other allegations are endangering the welfare of a child and domestic battery. Those were alleged to have occurred July 27th of 2024 in the area of 3301 Wood Avenue. And then there's an allegation of assault that was alleged to have occurred October 11th of 2024 in the area of 3301 Wood Avenue. If you are convicted, the city is seeking jail time. You have been appointed an attorney. We're going to have you leave the headphones on, but tell the person that gave you the headphones that you need to go to the virtual breakout room so you can speak to your attorney.
Done talking to
Mr. Lilich, did you have an opportunity to speak to your client?
I did. Thank you. Thank you, Your Honor. Your Honor, the city has made a plea offer to resolve Mr. Moore's pending matters. I have reviewed that plea offer with Mr. Moore. I've discussed with Mr. Moore his rights related to trial. He has opted to accept that plea offer. It's his understanding that that plea offer is that he will be pleading guilty to domestic battery, and that in exchange for that plea, the city will be moving to dismiss the endangering of the welfare of a child charge and the assault charge, and that the city will be recommending a 90-day underlying sentence, that after serving 2 of those days in jail, that Mr. Moore will be placed on probation on a condition that he obtain a domestic violence evaluation and follow the recommendations, not violate the law, and pay a $200 fine. Judge, I have explained to Mr. Moore, as a result of being convicted of domestic battery, he will be prohibited from owning or possessing a firearm while on probation. Mr. Moore has advised me that he has a pending felony matter. I have advised him that a conviction of this domestic battery count could negatively impact his criminal sentencing score for that felony case. Judge, having covered those caveats, Mr. Moore would like to enter into this plea agreement. We'd ask that the court adopt it as its order.
Okay. Mr. Moore, I want to make sure everyone is on the same page here. Is it your understanding of the plea, what Mr. Lilich detailed about pleading to the 1 count of domestic battery, the other matters would be dismissed?
Yes, sir. I mean, yes, ma'am. Sorry.
Okay, that's okay. And those rights that he was talking about, do you understand that you do have the right to a trial?
Yes, ma'am.
And do you understand that at a trial, Mr. Lilich or one of the other appointed attorneys would assist you at that trial?
Yes, ma'am.
And do you understand that if you did want to do a trial, you would have the opportunity to review the discovery, such as the police reports, prior to the start of that trial?
Yes, ma'am.
And do you understand that at a trial, your attorney would be able to ask witnesses questions, present evidence on your behalf, and that you have a Fifth Amendment right against self-incrimination?
Yes, ma'am.
And do you understand that if you did go to trial and you were found guilty, you would be able to appeal that decision to the Wyandotte County District Court?
Yes, ma'am.
And do you understand that entering a guilty plea to a count of domestic battery could have an impact on your criminal history score as it goes with you, as it stands for your district court case? Ooh, why am I having a hard time talking today?
Yeah, alrighty. Yes, ma'am.
Okay. All right. It looks like you've been in custody, Mr. Moore, since May 24th. So that mandatory 2 days, you've already got credit for that time. And then I see that on your district court case, I show 2 pending. When I looked this morning, which admittedly was like at 7 o'clock in the morning, so if they updated it since then, I wouldn't be able to see it. It looks like one of them is set for June 10th, and the other one I just didn't see a court date on. It doesn't mean that there isn't, it just means it hasn't been entered into the jail system yet. So what we'll do is we will put this on July 10th at 10 a.m. for a probation check-in. If you're still in custody on the county case, we'll just give you more time. If though you've been released on that district court case, you'll need to appear in person July 10th at 10 a.m. at City Hall.
And then give me all the information if I get released.
Yes, they'll give you
Okay.
a copy of the paperwork showing that, okay?
Yes, ma'am.
All right. Good luck to you, Mr. Moore.
Appreciate it. Thank you, guys.
All right. Have a good day.
All done there, Judge?
Yes.
All right, new pod, Mr. Fu Hokfai, I believe is how it's pronounced. Back soon.
Okay, I'm gonna work on that. Ms. Valdivino, on Mr. Moore, that traffic case that's from 2021.
Close.
Let's go ahead and just close that one, the one that was already in a payment status before he
Okay.
reached an agreement on
Sure.
this one. Thank you.
Mhm. For lack of ability to pay, Judge, or just
Yes, ma'am.
time? Okay.
Pardon me, Judge, Mr. Fuhakfai is ready.
Okay. Good afternoon, Mr. Fuhakfai.
afternoon.
Oh, there we go. Your attorney's coming on. Great.
Okay.
So it does look that he is being held in custody on our cases, Shane. And, the amount that is there is different than what we usually do. So I'm guessing this was meant to be a no bond hold, but right now we're having some issues actually getting no bond holds, communicated.
That's correct, Your Honor.
Okay, okay, fantastic. So, it looks, so what I can see on the jail screen, what is meant to be a no bond hold, it's a $900,000 cash alternative bond.
Understood.
But, sir, we're gonna have you speak to your attorney. You'll
Okay.
leave the headphones on and tell the
Okay.
person that gave you the headphones that you need to go to the breakout room, okay?
Breakout room. All right.
I have to step away for a moment. I'll be right back.
Yes, ma'am. Thank you. Judge Schultz just stepped away for a moment. She will be right back.
All right, thank you. Just stand by, sir.
Oh, shit.
Thank you for your patience, everyone. I had to step away for a moment. Did you have an opportunity to speak to your client, Mr. Lilich?
I did. Thank you, Your Honor. Your Honor, the city has made a plea offer to resolve all my clients' pending matters. I have reviewed that plea offer with him. I've explained to him his rights related to trial. I've explained to him that if he accepts this plea offer and enters in to a plea agreement with the city, that the court potentially could reject the plea agreement and sentence him to potentially the maximum sentence on all of his pending charges. Judge, I've also explained to him as part of this plea agreement, he'd be pleading to domestic battery. I've explained to him that while he's on probation for domestic battery, should the court grant him probation, he'll be prohibited from owning or possessing a firearm. And I have also explained to him that this plea agreement that's been offered would certainly negatively impact his criminal history score on any felonies that he may have pending. My client's advised me he has no pending felonies. Judge, his understanding of the plea agreement that's been offered by the city is that he would be pleading guilty to 4 counts of criminal damage to property, 1 count of domestic battery, 1 count of battery, 2 counts of trespassing, 1 count of interference, 2 counts of violating a protective order, and 1 count of criminal exposure. Judge, it's my client's understanding that in exchange for that plea, the city will move to dismiss the remaining charges, recommend a 8-month total underlying sentence, that he served 10 of the days in jail, and after serving 10 days in jail, be placed on supervised probation for 1 year on the balance of that 8-month sentence, on the condition that he obtain a mental health evaluation, follow the recommendations from that, and obtain a drug and alcohol assessment and follow the recommendations of that. Judge, my client understands those terms of the agreement. He would like to enter into that agreement and would ask that the court adopt it as its order.
Okay. Sir, I want to make sure that we are all on the same page. What Mr. Lilich just said about what the plea agreement consists of, is that your understanding of the plea agreement?
Yes,
And those rights that he was talking about, do you understand that you do have the right to a trial?
yes,
Do you understand that at a trial, Mr. Lilich or one of the other appointed attorneys would assist you at that trial?
Yes.
Do you understand that if you did want to go to trial, you would have the opportunity to review the discovery such as police reports to help you get ready for the trial?
Yes.
Do you understand that at a trial, your attorney would be able to ask witnesses questions, present evidence on your behalf, and that you have a Fifth Amendment right against self-incrimination?
Yes.
Do you understand that if you did go to trial and you were found guilty, you would be able to appeal that decision to the Wyandotte County District Court?
Yes.
Do you understand that by entering into this plea, it could affect your criminal history, specifically as it pertains to any felony cases that you might either have pending or have in the future?
Yes.
And do you understand that, like Mr. Lilich said, I do not have to accept the terms of the plea?
Yes.
Okay. I kind of briefly looked at the plea. Is it specified in the plea? Because some of them were 30 days. Is it specified that if additional time has to be served other than the 10 days, that the time is all consecutive?
I don't believe I put that in there, Your Honor, but that would be the city's request.
Okay, so I will go ahead and accept the plea with the terms that it's consecutive. Ms. Hutton, just for your edification, usually if you don't put something, we assume concurrent. So if you
Yes,
want
ma'am.
consecutive, just in the future, make sure that you do that.
Yes, ma'am.
Okay. Also, it's called a behavioral health evaluation, not a mental health assessment. So it looks like, sir, you have been in custody since May 26th. Unfortunately, I don't even know what the date is today, so I'm not. What is the date today? Is it the 6th? I don't.
And
Yes,
Judge,
ma'am.
just
It
for
is the
cla-
6th today.
Okay, thank you. Okay, so
Good.
he would have his 10 days in. Okay. Go ahead, Mr. Lilich. I'm sorry.
Thank you, Your
I
Honor.
cut you off.
Judge, just for clarification, I added up, there were on several of the charges, there was an underlying sentence. I
Okay.
added those up and came up with 8 months, and I did explain to my client that that would be consecutive together.
Okay, thank you, thank you. Okay,
And I am noting that, and also I'm changing I'm putting the behavioral health evaluation in place of the mental health counseling.
Okay,
I apologize. That was my mistake.
Mr. Viteri, I'm saying that correctly, aren't I?
You are, Judge.
Okay, okay, that's what I thought. I thought that it's called a behavioral health evaluation. Thank you. Okay, let's see. Got it. 4, 10, actually 11. Today is the 11th day. So what we'll do, sir, is you will get out later today. We
Okay.
finish the docket first before we send any of the paperwork over. So
Yeah.
it should be a few hours from now before you actually get released.
Yeah, Judge, last time they released me, they didn't release me till like 12 o'clock at night.
Yeah, trust me, it's also dependent upon how many people they have coming into the jail.
Okay.
I
Yeah.
mean, we finish it, we send our copies
Okay.
over, they get back to us about, oh, change this, change that,
Okay.
or everything's good, and
Okay.
then, depending on the influx of people coming into the
Okay.
jail, that's how they release people.
All right.
But you'll need to appear in person June 12th at 10 a.m. at City Hall for your first probation check-in.
Okay.
Fail to appear, a bench warrant with a no bond hold could be issued, so
Okay.
please make sure that you appear,
Yeah, I
okay?
will. Yeah, I will make sure I appear to
Okay,
the
thank
date.
you.
Yeah. Okay. Is that it?
That's it.
Okay, that's it.
Thank you.
New pod, Hewing or Harris? Hewing or Harris?
Thank you.
Pardon me, Judge, Mr. Ewing.
Okay. Oh, I guessed right too. That's the case I had brought up. Good afternoon, Mr. Hewing. I'm Judge Schultz with the Kansas City, Kansas Municipal Court. It looks like you are not being held on the city case. You have holds from the county and then also from Johnson County. But since you are in custody on the county stuff, we thought we'd see you on your city matter. It looks like there's an allegation of battery that was alleged to have occurred September 6th of 2024 in the area of 710 North 7th Street. There is the possibility of jail time if you are convicted. You have been appointed an attorney. If you just leave the headphones on and tell the person that gave you the headphones that you need to go to the virtual breakout room to speak to your attorney.
Virtual breakout.
Done talking with your attorney, he's gonna say something.
Mr. Lilich, did you have an opportunity to speak to your client?
I did, Your Honor. Thank you. Mr. Hewing is not,
Sorry.
no, bless you.
Thank you.
Mr. Hewing is not comfortable communicating with me electronically. Your Honor, I would respectfully request that the court set a date for him to be transported in person to municipal court for us to meet with him.
Okay, give me 1 second for us to get a date.
And
I want to make sure we're not conflicting with his district court case. I show that that is set on July 7th. So we want to make sure we're not on that date. We could do as quickly as June 20th, or we could do June 27th. Other than that, we're looking into July, which would be July 11th. Mr. Hewing, do you have a preference?
June 20th would not work. I have a pretrial conference that day.
Okay, well, good to know that. I didn't see that, but we could do June 27th. Because he's not being held on our stuff. So if he does somehow get released at that pretrial conference, then he could appear in person. Otherwise, we'll have him transported that day. Okay?
on June 27th, Your Honor?
Yes.
Thank you.
And that will not be a trial setting. That will just be for him to come over. I'm hoping you'll have some of the discovery that you can review with him at that time too.
Thank you, Judge.
Excuse me.
Yes.
Is there any way I can get my ROA sent over to me, or any kind of, like you said, the discovery or?
Well, you're not held on this case at all. Like
Oh, okay.
you were held on the county stuff. We noticed you were in jail. So we just said to the jail, hey, could we see him on our stuff? He'll be able to go over the discovery with you on June 27th. I believe often they let you meet in the office, right, Mr. Lillis?
They have, Your Honor, yes.
Yeah. So, I mean, it just depends on what's going on with the deputies that day. Either the two of you will meet in a courtroom or you'll be able to meet in their office, okay? All right, we'll see you June 27th at 1 p.m., Mr. Hewing.
Thank you, Judge.
Thank you.
Next will be Mr. Harris.
Okay.
How you doing, Judge?
I'm doing okay. And you, Mr. Harris?
Yes, ma'am.
Okay, Mr. Harris, I'm Judge Schultz with the Kansas City, Kansas Municipal Court. It looks like we have granted you an OR bond on our cases. You are being held on the county stuff though. So because of that, we went ahead and decided we should see you on your city cases. It looks like you have 2 allegations of petty theft pending. One was alleged to have occurred September 9th of 2024 in the area of 3901 Rainbow Boulevard. The other was alleged to have occurred September 12th of 2024 in the area of 1811 Village West Parkway. You have been appointed an attorney. So if you would leave your headphones on, but tell the person that gave you the headphones that you need to go to the virtual breakout room so you can talk to your attorney.
Can I ask you a question?
Mm-hmm.
I've been in here like 2.5 months. Like, is there any way I could get time served?
So I don't know what the offer is. I'm not allowed to see that ahead of time. And as I stated earlier, you're being held on the county cases, not on the city cases. You'd have to talk to your attorney about what the contents of the plea offer are, okay?
Okay.
All right. So if you could just let the person that gave you the headphones know that you need to go to the virtual breakout room, okay?
So up there. Okay.
Got it. I saw what you said. Keep those on. Breakout room, Judge?
Yes,
I'm sorry.
that's okay. Mr. Lilich, did you have an opportunity to speak to your client?
I did. Thank you, Your Honor. Your Honor, the city did make a plea offer. I did review that with my client, Mr. Harris. Mr. Harris would like these matters set for trial. He would request that the court set them far enough out so that he can meet with our office before trial.
Okay, so he is not being held on our cases. Are you, I know that his county case is set for June 23rd. I don't know what kind of hearing that is.
I'm sorry, can I
Go ahead.
speak?
No, go, yes,
Uh,
go ahead.
I get out on probation, then I'm like for sure guarantee getting out on 23rd. If you could, cause
So
can I
what we'll
explain?
do then is we'll put it into August. That way, when you get out after that next hearing, you'll be able to, you can come over to City Hall, go to room
Thank you.
212 and make an appointment to see your attorney, okay? So as soon as you get out, you want to do that. We're going to send over documentation that's going to show the trial date. Give me, and then, you know what, Ms. Valdivino, when you send that over, will you send a copy of the pink sheet for him too?
Yes, Judge, I
Okay.
will.
So then we're also gonna send over, Mr. Harris, a sheet that shows you how to make an appointment with your attorney. If you don't want to actually come in person to make the appointment, it's a
Okay.
sheet of paper that's got a QR code on it that you can use, okay?
All
Otherwise,
right.
you'll have to come in person to room 212. And I believe, Mr. Lilich, am I correct that the sheet of paper does mention the location of the office?
It does, Your Honor.
Okay, I thought that I was correct, but I wasn't sure. Give me 1 second.
A question,
Ms.
Judge.
Hutton, do you happen to know, the officer's day and time?
Sorry, Your Honor.
That's okay if you don't. This is.
I do not off the top of my head. I can find
Okay.
out.
No, that's okay. I'll just grab my list. Give me 1 moment.
Okay.
Okay, I grabbed it. Just give me 1 moment so we can figure out what day the officer is. Okay. He is a Friday morning officer. So that means we can set this trial for either August 8th at 8:30 or August 15th at 8:30. Which would you prefer, Mr. Harris?
The 15th. The
Sounds
further.
good.
Thank you.
Okay, so we will see you August 15th at 8:30 a.m. If something has happened and you are in custody, you will be transported, okay? So
Okay.
we won't let you go to Warren if you're still in custody, okay?
Thank you, lady.
All right, have a good day.
You too.
All right, Judge, new pod, new floor, Young or Davis?
Okay, thank you.
You bet.
Your Honor, I'm going to need to step aside for a moment.
Thank you for letting us know. Okay, he said Young, or what was the other name, anybody?
I'm sorry, ma'am. I don't think I caught it.
Okay, let's see. Young is in pot A. Anybody else in pot A? Davis is in pot A, so it's gotta be Young or Davis. Right? I hope.
Are those the last two, I think, or?
We do have one other, no, two others. Adrian Moda
One.
and then Shun Handy. He was not on the original list. He got booked on the 5th after I reviewed everything.
Okay, I
So you
probably
might
need
not
to,
have made an offer on that one.
I don't think I did. And what was the name again, ma'am?
Last name is Handy, Handy. First name is Shun.
Yeah, no, I didn't get an offer on that one, Ashley.
Yep, I'm working on it.
Thank
Sorry.
you.
Oh dear, that's a big.
phones. Pardon me, Judge, Mr. Davis.
Okay. Good afternoon, Mr. Davis. I am Judge Schultz with the Kansas City, Kansas Municipal Court.
Okay.
Can you hear me?
Yes.
Okay, give me 1 second to bring up your case. It was going to be you or another person, and I had a 50-50 shot, and I brought up the wrong person's case. So
Okay.
give me 1 second to bring up your case. Okay, Mr. Davis, it looks like you are currently being held on the city cases. You have been appointed an attorney because it looks like the city is seeking jail time on at least some of the charges. I'm going to read them to you quickly, and then we'll give you an opportunity to speak to your attorney. It looks like you have pending a driving under the influence of alcohol and or drugs, possession of paraphernalia. Those were alleged to have occurred June 7th of 2022 in the area of 635 and I-70. Then it looks like there's allegations of driving while suspended, violating a stop sign, no proof of insurance, and an expired tag. Those were alleged to have occurred July 18th of 2023 in the area of North 58th and Leavenworth. Then there's allegations of driving while suspended, driving under the influence of alcohol and or drugs, and possession of drugs. Those were alleged to have occurred September 23rd of 2023 in the area of 1843 Village West Parkway. It looks like, well, if you are convicted of driving under the influence of alcohol and or drugs, jail time is a possibility. In addition, there are mandatory fines, mandatory drug and alcohol counseling, and supervised probation. We'll have you leave the headphones on and then tell the person that gave you the headphones that you need to speak to your attorney in the virtual breakout room.
Yeah.
Get through talking to your attorney, if you would
Oh, wait, I want to make sure that they're ready. Okay. Mr. Lilich, did you have an opportunity to speak to your client?
I did, Your Honor. Thank you. I did visit with Mr. Davis regarding a plea offer that the city has made to resolve his pending charges. Your Honor, I did explain to Mr. Davis his absolute right to have a trial on these charges and his rights related to trial. Judge, after reviewing the city's plea offer with Mr. Davis, he'd like to accept that offer. It's his understanding of that offer that he would be pleading guilty to one count of operating a motor vehicle while under the influence of alcohol or drugs, and that in exchange for that plea, the city would move to dismiss the remaining charges. I have explained to him that one of those charges the city's dismissing is another DUI, and it's my understanding that the city may be referring that for felony prosecution. Um, his understanding of the plea agreement is that the city will be recommending on the plea to one DUI count a underlying sentence of 180 days, that he served 5 days in jail. After serving 5 days, he would be on probation on that balance for 1 year on a condition that he obtain a drug and alcohol assessment, follow the recommendations, not violate the law, and pay a total fine and costs of $1,273.50. Your Honor, Mr. Davis would like to accept that plea offer. He'd ask that the court adopt it as its order.
Okay. So Mr. Davis, I want to make sure that we are all on the same page here. That offer that Mr. Lilich just stated, is that your understanding of the plea offer? That the
Yes.
one case that's being dismissed, they will refer to the district court and it's up to the district court whether or not they file that?
Yes, ma'am.
Okay, and Mr. Lilich, there was a requirement for a drug and alcohol evaluation, is that correct? Or did I hear that?
That's correct, Your Honor. That's our understanding.
Okay, okay. And then I want to make sure, sir, that you understand your rights fully. Do you understand that you do have the right to a trial?
Yes, ma'am.
Do you understand that if you did choose to have a trial, Mr. Lilich or one of the other appointed attorneys would assist you at that trial?
Yes, ma'am.
And do you understand that if you did choose to go to trial, you would have the opportunity to review the discovery, such as the police reports, before the trial started to prepare?
Yes, ma'am.
Do you understand that at a trial, your attorney would be able to ask witnesses questions, present evidence on your own behalf, and that you have a Fifth Amendment right against self-incrimination?
Right. Yes, ma'am.
Okay, and do you understand that you do have if you did go to trial and you were found guilty, you would have the right to appeal that decision to the Wyandotte County District Court?
Yes, ma'am.
Okay, and knowing all of that, you're wanting to accept the plea?
Yes.
Okay. So you'll get out later today. We have to finish talking to everyone first, and then we send over the paperwork. So it could still be a few hours from now, but you will get released today. We will continue this for sentencing. Let's see. We need Ms. Valdivino, when you send his paperwork over to the jail, I need you to also send a drug and alcohol provider list, please.
Sure.
Okay, so we'll continue this for sentencing to July 3rd at 1 p.m. Okay?
Okay.
Okay, we will see you July 3rd at 1 p.m., okay? You
Okay,
make sure you get that drug and alcohol evaluation completed before that date, and they'll be sending you a copy of the provider list, okay?
all right.
All right, thank you. Have a good day.
Okay, thank you. Thanks.
Lavelle Young, Judge.
Okay.
Got water in it?
Good afternoon, Your Honor.
Good afternoon, Mr. Young. I am Judge Schultz with the Kansas City, Kansas Municipal Court. It looks like, okay, so what you have pending with the city court is a petty theft that was alleged to have occurred January 1st of 2023 in the area of the 5300 block of State Avenue. There also may be some sort of a traffic matter. You have been appointed, I'm not 100% sure about that one. You have been appointed an attorney to represent you. If you'll just leave the headphones on and tell the person that gave you the headphones that you need to speak to your attorney, okay?
Okay.
All right. Let him know you need to go to the breakout room. And
I need to
Mr.
speak to my attorney.
Lillich, he does right now have pending a $200 cash bond that he'd have to post.
Who me?
Yeah, but your attorney will talk to you about that, and he may be requesting an OR bond. I can't do anything about the county stuff, but
Yeah, breakout.
okay,
Thank you, Your Honor.
thank you.
Done talking to him.
Okay, so you know how I said there were 2 left? There were 3. Because I forgot about Mr. Young.
That's all right. We're making not bad time.
No, not really.
Your favorite things in the world. Love. Sherry, do you have the list of providers by chance? No. I had one and I think I threw it away. Definitely should have one. Yeah. Because I'm like, why should I keep this on the list if I don't? Well, I asked Kathleen. And then probably the one I have, I think was old.
Okay, Mr. Lilich, did you have time to speak to your client?
I did, Your Honor. And I did visit with him about the pending traffic matter, which I believe is attributed to a Lavelle Young with a date of birth of July 30th, 1927. He's advised me that he is not aware of any fleeing or eluding charge that he's ever received.
Okay.
Judge, as to the pending theft charge, the city has made a plea offer for Mr. Young to consider. I have reviewed that with him. I've explained to Mr. Young he does have an absolute right to have a trial on that charge. I've explained to him his rights related to trial. He has opted to accept that plea offer. It's his understanding that under the plea offer, he'd be pleading guilty to theft. The city would be recommending a 30-day underlying sentence, that he be placed on 6 months probation from that sentence on a condition that he complete a checkmate class, not violate the law, and pay a $150 fine. Judge, he would request that the court adopt that plea agreement as its order.
Okay. So, we will go ahead and leave that other case that's under the Lavelle Kayvon Young with that 7/30/1927 birth date. We will leave that in bench warrant.
Okay.
And that should not affect him at all with the difference in the birth dates. I want to make sure, sir, that you do understand the plea offer. What Mr. Lilich said about the plea offer is that your understanding of what you would be accepting?
Yes.
Okay. And do you understand that you do have the right to a trial?
Yes, I do.
Do you understand that at a trial, Mr. Lilich or one of the other appointed attorneys would help you?
Yes.
Do you understand that if you wanted to go to trial, you would have the chance to review the discovery, such as the police report, prior to the start of a trial?
Yes.
Do you understand that at a trial, your attorney would be able to ask witnesses questions, present evidence on your behalf, and that you have a Fifth Amendment right against self-incrimination?
Yes.
And do you understand that if you did choose to go to trial and you were found guilty, you would be able to appeal that decision to the Wyandotte County District Court?
Yes.
Knowing all of that, are you wanting to accept the plea?
Yes, ma'am.
Okay, so what we're gonna do is we'll continue this to June 12th for you to check in with probation at 10 a.m. You'll get out later today. We have to see everyone first, then we send
Okay.
over the paperwork. Oh, actually, wait, no, you're still held on the county stuff, aren't you?
What
But
counties?
it looks like 25 CR 621. Give me 1 second to see. The last time I looked it up was like around 7 o'clock this morning. So let me see if there's any update on that. No, well, now it says 6/17 instead of 6/21. So I guess that's earlier. Okay, but still, I'm guessing you won't get out until at least that date. So we'll put this on June 26th at 10 a.m. for a probation check-in. If you're
Okay.
still in custody on that county case, we will not let it go to bench warrant. We'll just push it to a different date, okay?
Okay.
All right, thank you.
Thank you.
Have a good day.
You too. Bye.
All right, Judge, next, new pod, Mota or Handy? I'll be
Okay.
back.
Thank you.
Quick break, ma'am. I will also be right back.
Absolutely.
Pardon me, Judge, Mr. Mota.
Thank you.
Good afternoon.
Good afternoon, Mr. Mota. Just give me one moment to bring up your case.
Yes, Judge.
Okay, so it looks like I'm Judge Schultz with the Kansas City, Kansas Municipal Court. I'm sorry, I should have said that first. You are not being held on the city cases, but since you are in custody on your county case, we figured we would go ahead and try to see you anyway.
Yeah.
And the city allegations that are pending are a domestic battery that was alleged to have occurred May 22nd of 2023 in the area of 221 North 38th Street. If you are convicted of domestic battery, there is mandatory minimum jail time, supervised probation, mandatory counseling, fines, and it can affect your right to own a weapon.
Yes.
We have appointed an attorney to your case. If you would leave your headphones on and let the person who gave you the headphones know that you need to go to the virtual breakout room.
Okay. I need to go to the virtual breakout room.
Julio, could you give me a call if you have a chance?
Sure.
too many people in there.
Yeah, I didn't want to make you wait.
Okay, Mr. Lilich, did you have an opportunity to speak to your client?
I did. Thank you, Your Honor. Your Honor, the city has made a plea offer to resolve Mr. Moto's pending domestic battery charge. I have reviewed that offer with him. I've explained to him his rights related to trial. I've explained to him the firearm prohibition that would go along with him being convicted of a domestic battery charge. After reviewing that plea offer with Mr. Mota, he would like to accept that offer. His understanding of the offer is that he'll be pleading guilty to domestic battery, and that in exchange for that plea, the city will be requesting a 90-day underlying jail sentence, that Mr. Mota serve 2 of those days in jail and thereafter be released on the balance on supervised probation for 1 year on the condition that he obtained a domestic violence evaluation, have no violent contact with the victim, not violate the law, and pay a $200 fine. Judge, after reviewing that with Mr. Mota and asking or answering related questions he had, he would request that the court adopt that plea agreement as its order.
Okay, Mr. Moda, first I want to make sure that you do understand the plea agreement. What Mr. Lilich just detailed about what the plea agreement is that your understanding?
Yes.
Okay, and then those rights that he was talking about, do you understand that you have a right to a trial?
Yes.
Do you understand that at a trial, either Mr. Lilich or one of the other appointed attorneys would assist you at that trial?
Yes.
Do you understand that if you did choose to do a trial, you'd have the opportunity to review the discovery, such as a police report, before trial started?
Yes.
Do you understand that at a trial, your attorney would be able to ask witnesses questions, present evidence on your behalf, and that you have a Fifth Amendment right against self-incrimination?
Yes.
Do you understand that if you did go to trial and you were found guilty, you would be able to appeal that decision to the Wyandotte County District Court?
Yes.
And do you understand that entering a guilty plea to a count of domestic battery could have an impact on your criminal history score in any kind of a felony case that you have pending or that may crop up later on?
Yes.
Okay. 1 second. Okay, so I show that you have been in custody since May 13th, so that mandatory 2 days that you would have to do, obviously you've already more than completed that. I also see that on your county case, you are scheduled for June 11th.
Yes.
So we definitely want to make sure we get past that date. We will schedule this for June 26th at 10 a.m. If you're still in custody on the county case, we will not let it go to bench warrant. We'll just give you a new probation check-in date. If you have been released on that county case, you'll need to appear in person June 26th at 10 a.m. at City Hall. If you get released on the county case, they'll give you paperwork showing that you need to appear June 26th at 10 a.m. at City Hall, okay?
Okay.
All right, thank you.
Thank you.
Just checking you're done there, Judge?
Yes, we are.
Our last person, Mr. Handy, may still be a little bit under the weather. Give me just a second to go see if he's competent to come back on the video, please.
Okay, sounds good.
You bet. Judge, we're gonna try, but I'm gonna give you a warning. It may terminate really quickly.
Okay,
All right, give me a second. I'm gonna have to go to him. We're gonna do it through the door, so I'll be
Okay.
back pretty quick.
okay.
All right, Judge, we're gonna try. He is here at the door.
Okay. Mr. Handy, I'm Judge Schultz with the Kansas City, Kansas Municipal Court. Can you hear me?
Speak up a little bit.
Yes, ma'am.
You said
Okay.
yes.
Okay, I heard that.
Okay.
It looks like you have pending, give me one second. Some charges with the city. It looks like I'm gonna quickly read all of the allegations to you, and then we're gonna give you a chance to talk to your attorney. The allegations are assault, that one's in payment status. Sorry. Failure to appear. That's alleged to have occurred February 7th of 2023 in the area of 400 Troop. Trespassing, that was alleged to have occurred March 9th of 2023 in the area of 630 Minnesota Avenue. Petty theft, that was alleged to have occurred April 4th of 2023 in the area of 2850 State Avenue. Loitering, that was alleged to have occurred April 29th of 2023 in the area of 722 Armstrong. Criminal damage and petty theft, those were alleged to have occurred January 10th of 2024 in the area of 10824 Parallel Parkway. Urinating in public and exposing yourself, those were alleged to have occurred May 28th of 2024 in the area of 645 Minnesota Avenue. Trespassing, that was alleged to have occurred September 5th of 2024 in the area of 701 Minnesota Avenue. Petty theft, that was alleged to have occurred October 16th of 2024 in the area of 3901 Rainbow Boulevard. And possession of paraphernalia in the area of, that was alleged to have occurred May 5th of 2025 in the area of 700 Minnesota Avenue. Mr. Lilich, I'm going to give you an opportunity to speak to your client. If it's not productive, just come back and we'll go from there.
Thank you.
I understand, Judge.
Thank you.
We're gonna put you in and let you talk to an attorney.
Yeah. See you all day. I've been
Okay.
Your Honor, we tried with Mr. Handy. We were on a productive path, but it didn't pan out.
Okay. Okay, right now, he would have to post it looks like he got booked in late enough yesterday that at this point, he'd have to post like a $3,000 cash bond. Would you like to make some sort of an argument, Mr. Lilich, on his behalf?
Yeah, Judge, I did have a conversation with Mr. Handy, and like I said, it was substantively productive for a period of time. It's obvious to me from my interaction with him, I think he's having at the present moment, he's having a combination of mental health and physical issues. I think he's sick, is my impression in several ways. I don't think it's doing either party any good that he remains incarcerated. As the court noted, he was arrested yesterday. I'd ask that the court consider those circumstances, grant him an OR bond, order him to personally appear at a date down the road if he can acknowledge and promise the court that he will appear at the date you order.
Mr. Viteri, and are you on the call because of Mr. Handy?
I am.
Okay. Okay. If Mr. Handy is released today, give me a ballpark estimate of whether or not you think you or the case manager would be able to get him into court.
Well, I can tell you this much, Judge. I know Mr. Handy has missed quite a bit of hearing in the past.
I know that's
And
where my concern comes in, but if he's also, physically ill, it's not fun to be sick anytime, but I'm guessing it is not comfortable being sick in jail.
right, of course. But I was gonna say there's also a few safety concerns too.
Okay,
In a past case manager, he had been aggressive towards them, and they didn't want to transport them in the car.
okay, I can understand that.
And
Okay.
if
Go
if I
ahead.
could speak up and clarify, Judge, he still may blow over the legal limit. That's why he's here. That's why he's in this
Bill?
protocol. Yeah. Yeah.
Okay,
He's 13 hours incarcerated, and
right,
he's
yeah.
still not dried out yet. Sorry, I'm just going to be
Okay, no,
blunt.
that's, okay.
I'm not a
Miss-
medical person, but
Right,
just to
right.
fill you
No,
in.
I know that you can't release people
Right. He is on the protocol.
until it,
Correct. So
yeah, okay,
medical would have to release him.
right, right.
They're going to make him blow and on from there.
Okay. Ms. Hutton, what is the city's position on bond?
Well, Your Honor, I would say that the city's pretty concerned about the likelihood of Mr. Handy appearing at court, and also is pretty concerned about the possible danger he might pose to himself or the community if he were to be let out.
So here's what I'm gonna do. Mr. Lilich, I'm not comfortable granting him an OR bond. I will lower it to a $500 cash bond. And then we'll put this on June 13th. And at that point, if Judge Whitman, I believe, will be hearing that docket. If she would like to, she can grant him an OR bond at that point.
All right. Thank you, Your Honor.
Okay. All
All
right,
right.
thank you.
Yeah, Judge, I have a question,
Yeah.
kind of off the wall. The inmates have asked me, are they getting the same defense attorney, from hearing to hearing to hearing? Is that how you guys are setting these up?
It's just one of them, and they
Okay.
have a system where they have, I mean, obviously I'm not privy to seeing the
Oh,
notes, but
okay.
Mr. Lilich and the other attorneys take
Okay.
very thorough notes, and they have a method of sharing those notes
Okay.
amongst themselves. And so any one of the attorneys should be able to look at the file and know what's going on.
Well, that's
Is
what
that
I've been telling them.
representation, Mr. Lilich?
Yeah, that's correct, Your Honor. Jim, we take notes electronically and enter them into a confidential platform. So any of the attorneys at this office can see what happened at the last hearing.
That's kind of what I felt, but I've been asked that the last couple of times. I thought I'd take a quick minute and clarify. So I can definitely pass that on and with assurances when I get asked that it's,
Okay.
Good representation.
Yep.
Okay.
Thank you.
Okay. Thank you all. Have a good weekend.
You too.
You too.
Bye.
Bye-bye.